Judges of the New York State Court of Appeals, let the Law Day ceremony begin. Please stand for the national anthem.
Oh, say, can you see by the dawn's early light what so proudly we hailed at the twilight's last gleaming, whose broad stripes and bright stars through the perilous fight o'er the ramparts we watched were so gallantly streaming, and the rocket's red ray, the balls bursting in air, came through the night, that our flag was still there. Oh, say does that star-spangled banner yet wave o'er the land of the brave and the home of the brave.
Good afternoon. A warm and sunny welcome on behalf of my Court of Appeals colleagues to everyone, every single one of you. Fellow jurors, welcome to our Law Day celebration. And thank you, Michelle Perry and your sons, for that beautiful rendition of our national anthem. And thank you as well to the Antioch Marching Band. Spectacular, both of you. And what could be better? Backed by popular demand, right? All across the nation, Americans are celebrating Law Day as they have every May 1st for nearly half a century, since this special day was first conceived by the American Bar Association back in the year 1958. It happens to be my very favorite day. Mayor Jennings, it's your favorite day too, isn't it? Originally intended as this country's counterpart to the Soviet Union's display of military might on May Day, Law Day for all of us is an occasion for rededication to the strength of this great nation, our rule of law. It's a reminder of the need for constant attention to the goal of providing a full measure of justice to all of our people. The American Bar Association every year chooses the nationwide theme for Law Day, and this year's theme is one that is especially dear to my heart. It's the American jury, we the people in action. The American Bar Association has also suggested that this year the festivities be extended beyond May 1st for a full week through May 6th, and we are very happy to oblige. Personally, I'm for continuing the celebration of jurors every single day, all year long. Putting a spotlight on the jury is a terrific Law Day theme. It reaches back into our history, remains vital today, and looks toward the future. Our founders viewed the right to trial by jury as essential to the protection of liberty, an anchor by which government can be held to the principles of its Constitution. And indeed, throughout America's history to this very day, juries have been a bedrock of our justice system and a unique opportunity for every citizen to come into the court as a participant in the third branch of government. Each year in New York State, we bring about 650,000 New Yorkers into our courthouses to serve as jurors, to assist in the delivery of justice. This is not only an exercise in citizenship for each of them, it's also hopefully a positive and educational and edifying, even enjoyable experience that fortifies their trust and confidence in the courts and in the justice system. Jury service has led to lifetime friendships, even to marriages. It's inspired jurors we know, like my daughter, to change careers, actually to study law. And a lawyer friend I spoke with the other day, who is general counsel of a major corporation, told me that her recent jury service, and this is a quote engraved on my heart, her recent jury service was among the great experiences of her entire life. Would that we could multiply that judgment by 650,000 every year. Regrettably, however, many members of the public are wholly uninformed about our prized jury system. They neither know its proud history nor its vital role today. For too many people, a jury summons in the mail ranks just above, slightly above, a tax audit or a root canal. They exclude themselves from jury service, believing negative images from the world of entertainment or fearing unwelcome interruption of their lives. Then, too, the unusual circumstances of a few media marathons eclipse the reality of jury service in the cases tried throughout our courts every single day, and that's really unfortunate. When more people are there to serve, the burden becomes lighter for everybody, and the array of potential jurors becomes more diverse, as it should be. In the end, it's not fair if you're not there. It's not fair if you're not there. That's a simple truth. The system works only when everybody does their part. So getting the word out to the public about juries and the jury system is a huge part of our Law Day celebration. We want to encourage people to seize the power, to take the opportunity to think inside the box, the jury box, that is. And as part of spreading the word during our own juror appreciation activities, Mark Zauderer, a wonderful New York City attorney, chair of the Jury Commission, has arranged for town meetings across the state. And Mark, welcome. I know you're here in the audience today with your partner, Joe Finnerty, and we welcome you both. There'll be a town meeting immediately following this ceremony right here in our courthouse. And next week, there'll be town meetings in Syracuse, Buffalo, Manhattan, and Central Islip. These, we know, will be lively and enlightening exchanges with students and judges and court staff and former jurors about jury service and about the jury system. We hope you will attend. In that same vein, throughout New York State, courts and bar associations and community organizations will be sponsoring all sorts of Law Day and juror appreciation events. Many will be giving out tokens of appreciation, as we will today, like bookmarks about jury service and even a gavel keychain. I know how much you're all looking forward to that. There'll be a flood of radio announcements promoting jury service all through next week. You can't avoid them. And there'll be posters at major airports throughout the country featuring Harrison Ford in his role as a former juror. These are just a few of the ways that we will be reaching out to the public, both to raise awareness about jury service and to tell jurors, to tell the public that we genuinely appreciate their jury service. But our Law Day celebration has a second aspect. It's a two-part deal. We, the court insiders, need and expect the public to honor its responsibility to serve. We, in turn, must honor our own responsibility to make their jury service a good one. Always, jurors' time should be valued and respected, proceedings made efficient and understandable, and facilities kept adequate and clean. So the second part of this Law Day celebration is our own renewal of that pledge to the public. We, too, must seize an opportunity, and that is the opportunity to earn public trust and confidence by our conduct of the jury system. Indeed, over the past decade, a spirit of jury reform has swept courthouse corridors throughout the nation. In New York State, we began a serious reform program more than a decade ago, and we continue to work hard at it every single day. Juror facilities have been upgraded, compensation increased, the term of service shortened, automatic sequestration abolished, and the period between jury calls lengthened. One day, one trial has become the norm in many counties throughout the state, serving both juror and employer convenience. We've expanded source lists to bring more people into the pool. New York uses the broadest array in the entire nation in calling jurors. Automatic exemptions have been abolished so that now everyone can serve, including lawyers, judges, and yes, even chief judges. Indeed, it remains an unfulfilled dream of mine to be selected as a juror. Presiding Justice Cardona, of course, has already achieved that distinction. But pleased as we are with what has been accomplished to date in New York State, our work is far from complete. The fact is, as jury reform has swept the nation, there has been a great deal of learning and scholarly attention paid to the subject, and a great deal of experimentation within many of our sister states, and many new ideas have emerged. They've been tested elsewhere to promote better utilization of court time and greater comprehension for jurors, in short, to improve the experience for everybody. It is, after all, true in this modern age of technology and communication that we listen differently and we learn differently. The public brings new expectations into our jury rooms. We have to know them and we have to meet them. On Law Day, we recommit ourselves to continuing the spirit of reform. We owe that to the public so that our prized jury system remains true to its historic objectives while serving the needs and expectations of modern-day society. I conclude my own Law Day remarks by coming full circle to my opening thought. We have the perfect Law Day theme this year, don't we? The American jury, we the people in action. By focus on the American jury, we reflect on the history of this great democracy, on the vision and on the values of our founders, most especially on the right to trial by jury, on the unique privileges and responsibilities that we have today as beneficiaries of the American justice system, and on the cherished trust we in the courts and in the bar have as guardians of the rule of law. And that brings my own remarks to a conclusion. And I have the very great pleasure now of calling upon our remarkable Lieutenant Governor, Mary Donahue, known to us all here at the courthouse as Judge Donahue. Good afternoon.
It's always a pleasure, Chief Judge Kay, to join you and everyone here on this day. Once again, it's an honor to be with the judges of the Court of Appeals, Judge Lippman, Attorney General Spitzer, Mark Zador, Chair of the Commission on the Jury, New York State Bar Association President Kenneth Standard, and all who have taken the time from your busy schedules to celebrate Law Day. I always anticipate this responsibility in my job with great enjoyment. Seeing so many of my friends and colleagues here, law students, including this year, my daughter, Sarah Kenny, who's a student at Albany Law, fourth-generation lawyer in the family. How about that? We want to continue that theme. Here to reflect on the enormous role that law plays in our society. As in the past, I'm here to set the stage for the activities to follow and to open discussion on the topic of the day, the American jury, we the people in action. As residents of New York State and citizens of the United States of America, we enjoy countless benefits from our government. We are free to enjoy our lives and to pursue happiness, to come and go as we please, to travel on well-maintained roads and safe neighborhoods, and to rely on our local, our state, and our federal governments to serve us well. In exchange for the many benefits we enjoy, relatively little is asked of us in return. We are expected to obey the law, to pay our taxes, to cast our votes in local and national elections, and on occasion, to serve on juries. As a former litigator, prosecutor, and judge, I have had the benefit of unique and personal experiences with our jury system. Juries have awarded my clients for their injuries to make them whole. Juries have sent criminals that I prosecuted to jail to protect our communities. And juries have rendered decisions in cases I presided over as a judge. I know well the importance of having a complete, diverse jury pool. I respect the process as a foundation that makes our government strong. Ironically, I've never been selected to serve on a jury, although I've answered the call a few times. Can you understand that? Why wouldn't someone want me on a jury? I'll keep trying. The American jury is indeed our people in action. It is one of the pivotal characteristics which makes our country what it is today. The jury concept itself is centuries older than our country, and it is one of the basic tenets upon which our country was founded. In the Declaration of Independence, among the offenses charged against the monarchy, Jefferson wrote, "The king was guilty," and I quote, "for depriving us in many cases of the benefit of trial by jury." Upon the establishment of our fledgling country, the guarantee of trial was so important to our founders that it was established as an individual right in both the original text of the Constitution of the United States and in our Bill of Rights. In the original text, it was so important for our founding fathers to guarantee the existence of the jury as one of the fundamental and governmental institutions upon which our country was built. In the Bill of Rights, the jury was reiterated and restated as an individual liberty which all citizens should be guaranteed. Juries have been a vital component of the justice system all the way throughout our country's history, from their use during the colonial period, long before our fight for independence, to Stokes in 1925, the first jury trial broadcast live on the radio to the nation, to the Price, Mississippi burning trial of the late 60s, when the first ever convictions in Mississippi for the killing of a civil rights leader were decided. Juries, every step of the way, have played a crucial role. Just as our laws and our attitudes have changed and adapted to our changing times, so too must and has the jury system. For better or worse, with the advent of court TV and worldwide instantaneous internet news coverage, the jury, as a governmental institution, has been impacted. Our individual lives have become more and more fast-paced, and our time more precious to us. So, too, our attitudes as potential jurors have changed. For many people, receiving that notice in the mail, as Judge Kay mentioned, from the local court, I consider it might be like the postal equivalent to getting pulled over by a trooper on the thruway. You got caught, and the first thing that runs through your head is, how am I going to get out of that? Of course, let me assure you that would never occur to me. As jurists, as members of the bar, and as elected officials, we are the ones who can and who must endeavor to improve this system and to change those attitudes in order to save the jury system as an institution and as an individual liberty. During the past decade, Chief Judge Kay has made this one of her top priorities. Beginning in 1993, the Chief Judge formed a 30-member task force, the Jury Project, which produced a report that served as the outline for major reforms to our jury system in New York State. She mentioned a few of them. Lengthening the time between serving as jurors has been an assistance to many people. The use of multiple and better integrated source lists, along with the 1995 abolition of all exemptions and disqualifications, and improving communication with jurors themselves, has been another one of the very important recommendations and improvements. In 2003, Chief Judge Kay announced the creation of the Commission of the Jury, marking the second phase of jury reform in our state. Chaired very ably by Mark Zauderer, the Commission continued to study the issue and made recommendations in their interim report last summer. The improvements suggested by the Commission have been very beneficial, especially reducing the unnecessary waiting time for jurors, mandatory settlement conferences before the juries are picked, enhancing services and the amenities that are available to jurors, and overall making jury service more desirable. Less than a year later, I'm very impressed to see that many of the Commission's recommendations and other changes have been implemented in courtrooms across the state. For example, I read recently in the New York Law Journal about my former colleague, Justice Joseph Sykes, Supreme Court Justice in Montgomery County, and his successes with juror questioning and other practices to actively involve members of the jury. Sometimes there's been a fear of that. I recall that as recently as the late 90s when I was on the bench. It's refreshing to see us having the courage to involve the jurors directly in the questioning process. These are just a few changes in one county which are making jurors' experiences more meaningful. We should all regard these historic improvements, as well as others across the state, as models to emulate. I firmly believe, based on my professional and my personal experience, that only the fear to make the appropriate changes will drastically erode our jury system irrevocably. We must continue to move forward with these changes. We also must endeavor to improve the jury system by changing the negative attitudes towards service. We are very fortunate that we have the able leadership of Chief Judge Kay to achieve these goals. But we should not place that burden solely on her shoulders. Jury service is an empowerment by, of, and for the people. This message must be spread by each of us as professionals working with the system across our great state, so that citizens will willingly and enthusiastically participate in this precious opportunity to take action as jurors. The residents of our state who respond to the call for jury duty are really examples to all of us, and they deserve our appreciation and respect. That's why Governor Pataki was proud to proclaim next week, May 2nd through the 6th, Juror Appreciation Week. Whether or not a person actually becomes a member of a jury, it is the willingness to participate in the system which ensures the continuation of one of our most valuable institutions and individual liberties. In conclusion, my message to you today is our responsibility as judges, as members of the bar, as individuals working within the justice system, to enhance and support the work of Chief Judge Kay, Judge Littman, and the Commission on the Jury. I am confident that if we all work as a team in this important endeavor, that this institution will be preserved long after us as one of the most valuable and precious pillars of our democracy. Thank you.
Thank you so much, Lieutenant Governor Donahue, for that message. A remarkable Lieutenant Governor, lawyer, judge, and I have every confidence that you would be a superb juror, and I am prepared to offer my recommendation at any time you think it would be appropriate. As long as I've paused in the program, I want to bring to the attention of all of you the work of my Court of Appeals colleagues today. They ask that there be sufficient sunshine to blanket all of you, and look what they have done. A round of applause for all of you. Quite frankly, I think they could have been a bit more generous. It's freezing up here. But I'll take it. I'll take it. Attorney General Elliot Spitzer, our phenomenal Attorney General, would you please come join me in this cold and freezing place to deliver your Law Day message?
Guests, members of the bench, colleagues, Judge Kay, I will try to warm up the lectern. It seems a little hard to do. Thank you, Judge Kay. You are truly the hero of today's Law Day, for there is no one who has done more to bring New Yorkers into the jury room and to make all of us realize that serving as a juror is not a duty, but a privilege. Thank you, Judge Kay. On this year's Law Day, we pause to consider the jury. Since the beginning of colonial times, the defendant's right to a trial by jury has been a central feature, not just of the American justice system, but also of our unique vision of democracy. John Adams proclaimed the jury the lungs of liberty, and Thomas Jefferson declared that the trial by jury was, quote, the only anchor ever yet imagined by man by which a government can be held to the principles of its Constitution. In spite of this lofty phrase, debate over the scope of the right to a jury trial very nearly derailed ratification of the Constitution. While the initial draft of the Constitution provided for the right to a trial by jury in criminal cases, it did not provide such a right for civil cases. The Federalists and Anti-Federalists battled bitterly over this issue. Compromise ultimately was forged, and when James Madison penned the amendments to the Constitution that would become our Bill of Rights, the right to a jury trial in civil cases was included in the Seventh Amendment. But the civil jury has never really escaped the debate that surrounded it at the founding of the nation, nor has it attained quite the same exalted status in our legal imagination as its sister, the criminal jury. Nonetheless, we have retained our fealty to the institution, though over the past 200 years, its role has frequently been questioned. At issue is the fact that jurors today must render verdicts in cases as diverse as securities litigation, antitrust, product liability, toxic torts, and intellectual property. These cases can sometimes turn on factual determinations involving esoteric financial, scientific, and technological evidence far outside the average citizen's knowledge or experience. In addition, these suits are likely to be of long duration, to involve multiple parties and claims, and extraordinary amounts of evidence. It is for these reasons and more that questions about the fairness of the civil justice system have arisen in recent years, and increasingly, these questions are focused on the capacity of lay juries to adjudicate such disputes. While some dismiss these concerns, they have been expressed by Supreme Court justices as well as eminent legal scholars. And we shouldn't be cavalier about such criticism because the outcomes of many of these cases are of critical importance to our society. They can alter the behavior of entire industries or change the balance by which we weigh the benefits of scientific innovation against the risks that it poses. As such, the issues are worthy of our attention and careful consideration. Now, in proceeding in this task, it is helpful to first consider the social values we rely on the jury system to promote. They fall into two general categories. First, as de Tocqueville recognized, service on a jury furthers civic participation. It brings to bear the varied perspectives of the diverse citizenry on resolution of important issues of the day, and it ensures that jury verdicts reflect the shared norms and values of the community. And second is the jury's truth-seeking function. Given our adversarial trial system, we marshal juries composed of neutral citizens because we think they can best weigh the competing presentations of lawyers, assess witness credibility, and then determine what occurred and whether liability should be imposed. As a result of this process, jury verdicts also serve a regulatory function by requiring corporations to weigh the potential costs of their actions. But in civil cases where the jury is called upon to decide matters that turn on highly specialized scientific, technological, and economic concepts, we can see that these twin purposes of the jury system may, in certain cases, come into conflict. While there is no doubt that jurors approach their duties with the utmost diligence and care, even the most conscientious and deliberative juror would have a difficult time with the kind of statistical data at the heart of today's increasingly complex scientific or technical evidence. Mark Twain captured the general level of discomfort with statistics when he noted that there are three kinds of lies: lies, damn lies, and statistics. Consider one scholar's plain language explanation of the correct formula a jury should use to weigh probabilistic evidence. And I quote, "The new odds of guilt or liability equal the percent chance that the new evidence indicates the defendant's guilt or liability, divided by the probability that the new evidence implicates another, times the prior odds." You can see Mark Twain's point. The Supreme Court has observed that the primary value served by due process in fact-finding procedures is that it minimizes the risk of erroneous decisions. But a confused or overwhelmed jury or judge will be less likely to provide such a safeguard. If verdicts are not based on factual determinations bearing some reasonable degree of accuracy, legal rules and remedies cannot be applied consistently across cases, and that may diminish the public's trust in our judicial system as a whole. But what might we do to unify the jury system's goal of inculcating democratic spirit in the citizenry with the procedural fairness that is the heart of due process? Generating answers to this question will require all of us to engage in an honest and open dialogue about the present system's merits and shortcomings. It will also require us to think creatively and expansively about potential reforms, both small and large. For example, some have argued that it would aid juror comprehension if juries were more actively involved in complex civil trials. Proponents of this view suggest that jurors be permitted to ask questions of the judge or witnesses, or to take notes during the proceedings. Others have suggested that the proper course lies in having judges issue better instructions in complex cases. Indeed, the New York court system, under the leadership of Judge Kaye, has instituted important revisions of pattern jury instructions to simplify and clarify complex issues for juries. Other reform proposals envision more significant alterations to the civil jury's role. For example, some have suggested impaneling expert juries in highly complex cases, sometimes called blue ribbon juries, and certifying certain technical determinations to that jury. In a variation on the theme, some have proposed that expert non-jury panels should hear complex civil cases as judges would in a bench trial. Finally, some have argued that judges should decide issues deemed too complicated for the jury. Of course, each of these proposals presents important constitutional and policy questions, as well as questions about implementation that should not be underestimated and that demand our careful scrutiny. Yet these issues clearly are too important to shy away from, and it is incumbent upon us as leaders of the legal community to confront them. Our courts have recognized the constitutional guarantee of a jury trial envisions a fair jury trial. Thus, just as the technical and scientific innovations for which we are justly famous have bequeathed us progress in the way our lives are lived, they demand from us progress in the way our disputes are adjudicated. As the history of the Seventh Amendment counsels, it is this spirit of debate and adaptation that has imbued our civil jury system with the dynamism to survive and which has rendered it a uniquely American institution. Thank you so much.
Thank you so much, Attorney General Spitzer, for your very stimulating remarks. Indeed, I do feel a little bit warmer. I do. And I would next like to call upon our spectacular neighbor, President of the New York State Bar Association, Kenneth Sanders, for his Law Day message. And by the way, County Executive President, is this your favorite day too? Good. President Sanders?
Chief Judge Kaye, Lieutenant Governor Donahue, Attorney General Spitzer, members of the Court of Appeals, colleagues of the legal profession, and colleagues of the jury box. I'm glad to be here this Law Day for the traditional gathering of our three branches of government and of the New York State Bar Association to publicly celebrate and reaffirm our commitment to the rule of law and to the distinct responsibilities necessary for its preservation. Certainly central to the rule of law is the American jury, but juries are only effective in an independent court system, a court system and independence of which I feel is threatened. Just a month ago, as the State Bar's Executive Committee was meeting at the Bar Center across the street, a member of our committee entered our meeting room and quietly advised us of news reports that Terry Schiavo had died. All of us there felt sorrow and empathy for all of the individuals involved in that public tragedy. Beyond those feelings, however, what lessons should each of us take away from those events? For years, as part of our public education initiatives, the State Bar Association has been providing information on procedures and documents to help New Yorkers plan and communicate in advance their wishes for care against the possibility that due to illness or injury, they later become unable to do so. Ms. Schiavo's plight touched many Americans in a way our Bar Association by itself could not, bringing home the importance of advanced planning. The heightened attention to this issue was demonstrated by the more than 100,000 visits to our website in just 10 days to access the forms and information needed for advanced health care planning. The Schiavo case also is an example of the varied matters affecting individuals and society in important ways that come before our courts on a daily basis. Our judges, as seen in this case and others, are charged with applying the law to the matters before them with fairness and impartiality, all the while remaining immune to outside influences. The situations presented may be complex. They may involve emerging areas of the law. They may be heart-wrenching, and they may spark intense emotions in public debate and political opinion. However, the mandate for our courts is always the same: to be a neutral arbiter. That, of course, is why the founders of our government carefully provided for separate but equal executive, legislative, and judicial branches, and for our judicial branches to be independent, yet accountable. As Supreme Court Justice Sandra Day O'Connor has observed, judicial independence is not an end in itself, but a means to an end. It is the kernel of the rule of law, giving the citizenry the confidence that the laws will be fairly and equally applied. In the Scheibel case, sadly, we witnessed not only political and partisan rhetoric, but attempts by government representatives to blur, indeed to erode, these long-established lines of separation of powers so critical to our republic. After adverse rulings in state courts, unprecedented emergency legislation was enacted very publicly in Washington, authorizing federal courts to again hear the Scheibel case, again with similar results. A U.S. Court of Appeals judge wrote in the final appellate decision in the matter that the legislative and executive branches of government have acted in a manner demonstrably at odds with our founding fathers' blueprint for the governance of a free people, our Constitution. Following that, there then came the extraordinary attacks by some lawmakers on the judges involved in the state court and federal court decisions. That wasn't all. There was talk of a judiciary run amok. There were calls for reasserting constitutional authority over the courts and the taking of steps so that judges will, quote, answer for their behavior. There were also reminders of lawmakers' budgetary authority over the judiciary and a resurfacing of proposals to impeach, again a quote, activist judges, and to remove certain issues from court jurisdiction. Even more disturbing was what I hope was merely an artlessly phrased rhetorical question from a senator as to whether there is a cause and effect connection between a public perception that some judges are making political decisions and the recent violence that has been directed against representatives of the courts and their families, though he did add that such action certainly would be without any justification. Verbal and even physical attacks on the judiciary are not new, nor is the state bar's response to such attacks. Throughout our history, we have spoken out to remind all concerned that there is a significant difference between constructive criticism of procedures, the law, or of judicial decisions, and attacking judges personally for merely doing their duty. A duty that sometimes results in unpopular decisions with which we may disagree. For one example, we can turn back to Franklin D. Roosevelt's 1937 proposal to pack the court, to add justices to the U.S. Supreme Court after that body made several adverse rulings on his New Deal legislation. In a resolution passed at that time, the state bar declared that the public's focus should not be limited to the specifics of the president's proposals, but instead the real issue with which we needed to confront should be clearly understood by the people. And that issue was that the civil, political, and religious liberties of every American citizen depend basically on an independent judiciary, and that nothing is more vital to the preservation of liberty than an independent judiciary. For another history lesson, we can look to the U.S. Supreme Court's unanimous and now generally celebrated ruling written by then Chief Justice Earl Warren in Brown v. Board of Education 51 years ago, invalidating the separate but equal doctrine in education, which at the time generated strong responses pro and con. There are some among us who recall seeing the impeach Earl Warren billboards that were put up in some areas of the country as an example. Of more recent vintage, we may remember some of the rhetoric in the mid-90s that called for the resignations or impeachment of certain federal judges based upon their decisions. Those statements drew an outcry from numerous bar associations across the country, not the least among them ours. At every opportunity, our bar association has sought to educate the public, pointing out how essential is judicial independence to the effective functioning of not just our judicial system, but of our society as a whole. We have explained that there are appropriate avenues for action for those unhappy with a judicial decision. Among those avenues are appealing that decision, engaging in vigorous but civil debate of the issues, and working for change in the law through constitutionally sound legislation. We also have noted the existence in New York State and at the federal level of a judicial code of conduct and of complaint and disciplinary procedures for concerns about judicial demeanor, honesty, or competency. We have seen both the federal and state processes separately at work as recently as this month. We also have stressed that in the bar that unwarranted attacks and pressures on the judiciary can create confusion among the public as to the judiciary's appropriate responsibilities and undermine confidence in the legal process, in government in general, and in those who are in public service. Let me share with you now the words of Justice Thurgood Marshall in a 1981 speech to the Second Circuit Judicial Conference in the wake of criticism that judges and court procedures should assume new roles in the fight against crime. He observed, "We must never forget that the only real source of power that we as judges can tap is the respect of the people. If we are perceived as campaigning for particular policies, as joining with other branches of government in resolving questions not committed to us by the Constitution, we may gain some public acclaim in the short run. In the long run, however, we will cease to be perceived as neutral arbiters, and we will lose that public respect so vital to our function." Law Day has become a traditional time for us to pause and reflect on these precepts that serve as critical underpinnings of the rule of law. In that spirit, I ask each of us today to reaffirm our commitment to preserve the distinct and separate roles of the three branches of government and the essential element of judicial independence coupled with accountability. These principles have withstood much wear and tear, but need our protection and nurturing if they are to continue to garner and deserve the public trust for years to come. Just what do we ask? Admittedly, we ask much. Of our judges, we ask for consistent, even-handed, and impartial application of the law to all the cases that come before them. We ask that they carry out this responsibility removed from outside influences or the perception thereof. We ask that they be competent to handle their task and that they be diligent in their work habits. We ask judges to maintain a delicate balance of decisional independence, discretion, self-restraint, and accountability. Of those in the executive and legislative branches, we ask for a focus on legislating and enforcing laws. We ask the executive and the legislators to provide adequate funding and other resources to the courts, and to refrain from and reject proposals that, because of disgruntlement with certain court decisions, would cut or freeze judiciary budgets or salaries, curtail courts' traditional areas of jurisdiction, or otherwise threaten judicial independence. We ask those who nominate, appoint, or approve judges to select only the competent, the diligent, the even-tempered, and the fair-minded. Further, we ask that lawmakers resist engaging in political rhetoric that attacks judges for doing their sworn duty. And we urge lawmakers to repudiate such pronouncements by others, including by their colleagues. Of members of the bar, we ask that they take every available opportunity to draw attention to the vital need to maintain the separation of powers and judicial independence, and to remind everyone of the constructive means available to express criticism of judicial decisions. Additionally, we look to bar members and bar associations in particular to continue to speak out against attacks on the judiciary and to explain why such attacks are so destructive of respect for the rule of law and threatening to our democratic society. Members of the legal profession and lawmakers, given their positions, have a special responsibility to speak with discretion and in a constructive manner concerning the administration of our government and of our system of justice, and to be aware of the impact of their words. We also need to do all we can to build and maintain support for our independent juries. We need to make jury service as safe, convenient, and comfortable as we can, and to treat jurors with the great respect they deserve. We also need to educate them as to how essential their role is to preserving a democracy. The State Bar, a number of other bar associations, and many individuals in New York have long been active in educational efforts and in responding to unwarranted criticism of judges as they carry out their duties. We must continue and indeed expand these efforts. Preserving the separation of powers, however, does not mean that we cannot engage in frank discussions with each other about applying these principles in challenging circumstances. In fact, a dialogue involving representatives of the three branches of government in New York State regarding judicial attacks, their implications, and alternatives may be very desirable. It may well be helpful to hold such discussions privately initially, and later to have similar public discussions. Public discussions would present a wonderful opportunity to educate all New Yorkers and a possible opportunity to encourage more citizen interest in and engagement with our society. Jury service and voting are two essential points of engagement. These responsibilities of building and maintaining a democracy may not be easy ones, but there are no duties more important. Thank you very much.
President Standard, Ken, thank you so much for your stirring and wonderful message. I refer to the Lieutenant Governor as remarkable, and she surely is, and I refer to our Attorney General as phenomenal, and he surely is. And I refer to our State Bar President as spectacular, and he surely is. I just haven't hit on exactly the right words of praise. I don't think I have sufficient words of praise for our next speaker, the Honorable Jonathan Littman, the Chief Administrative Judge. And as he makes his way up to the North Pole, I would like to say this. And that is that I'd like to tell you something about this blouse that I'm wearing today. I wore it for the first time on Law Day 2001, May 2001, when we presented a Merit Performance Award to Senior Court Officer Mitchell Wallace. Senior Court Officer Mitchell Wallace, along with Captain William Harry Thompson, and Senior Court Officer Tommy Jurgens gave their lives at the World Trade Center on September 11, 2001, just barely 4 months after Mitch stood here to receive his award. I wear this blouse every year on Law Day and only on Law Day, and will continue to do so as my own private tribute, now public tribute, to all of them, the three of them, but in a sense, to other heroes of the court system, and by that I have in mind our court officers and our court employees, and I would appreciate a round of applause for all of them. And now I would like to call on Chief Administrative Judge Jonathan Lippin.
As we gather today on the steps of the Court of Appeals Hall in observance of the 47th anniversary of Law Day, we also make it a point to recognize the thousands of devoted and hard-working court system employees who make the third branch of government work. It is my pleasure to again this year present the court system's Merit Performance Awards. For our first award, I'd ask Gloria Chandler, Chief Clerk and Commissioner of Jurors of the Otsego County Supreme and County Courts, to please come forward to receive a Merit Performance Award for superior work performance. Gloria. Gloria Chandler is a highly respected veteran of the courts whose energetic personality and great dedication to her job was severely challenged in July 2003 when she learned that she had cancer. Gloria eventually went through surgery, chemotherapy, radiation, along with all the physical and emotional distress. But true to her strong spirit, she never got down or stopped thinking about the needs of the courts. In the days leading up to surgery, Gloria called a staff meeting where she courageously broke the bad news to everyone and then outlined a detailed plan of action that anticipated all of the court's upcoming needs. Most impressive of all, she kept right on working from bed following her surgery, and just 8 weeks later, she was back at the courthouse. In between debilitating courses of chemotherapy and radiation, she was on the job, staying focused and busy, and always smiling and making everyone feel good with her wonderful grace and sense of humor. Gloria, for inspiring all of us with your remarkable perseverance and commitment to our judicial system, we present you with this year's Merit Performance Award for Superior Work Performance. For our next award, I'd ask Toya Young, Lieutenant, Kings County Civil Court, to come forward to receive a Merit Performance Award for outstanding educational efforts. Lieutenant Toya Young volunteers hundreds of hours of her time every year to make a positive difference in the lives of school children of all ages, including many at-risk youth. Drawing on a life experience, wisdom, and warm, engaging personality, she inspires these young people with the possibilities of the future and helps keep them on the right side of the law. Toya has put together workshops on gang violence at local schools, taken a personal interest in many troubled girls, and invited special needs teens with an interest in the law to accompany her on her courthouse rounds. Toya's contributions are not limited to young people. She has also organized seminars directed at educating low and middle-income minority women on important safety and self-esteem issues. Next fall, this wonderful role model will enter the Hunter College School of Social Work in pursuit of a master's degree. Toya, for the selfless way in which you go about your life's mission of putting young people on the right path. We are so pleased to present you with this year's Merit Performance Award for outstanding educational efforts. For the next award, I'd ask Carl Orapallo, Esquire, Principal Law Clerk, Onondaga County Supreme Court, to come up to receive a Merit Performance Award for community service and humanitarian pursuits. Working at the Onondaga County Family Court over the last 36 years has made Carl Orapallo painfully aware of the many difficult problems afflicting families and children today. The lifelong Syracuse resident and active member of his local church has worked tirelessly to help underprivileged people, beginning in the 1970s with the establishment of a multi-service community center in a struggling Syracuse neighborhood that today provides preschoolers to senior citizens with many nutritional, educational, and other programs. Over the years, Carl has been the driving force behind several new housing and community projects. And since February 2001, he has devoted himself to building new lives for refugees fleeing the violence and oppression of the war-torn Sudan. He has stepped in repeatedly to arrange for food, clothing, housing, education, transportation, and jobs. Carl, in recognition of your unflagging friendship to those in need and your untiring efforts to improve conditions in your community, it is our great privilege to present you this year's Merit Performance Award for Community Service and Humanitarian Pursuits. For our final award, I'd ask Gary Diesel and Gregory Gerner, Court Officers, Nassau County District Court, to come up to receive a Merit Performance Award for heroism. Court Officers Gary Diesel and Gregory Gerner were on duty this January 20th when they noticed thick smoke emanating from the downtown Hempstead area. The pair wasted no time in finding the source of the smoke. They arrived at a harrowing scene, a burning three-story building, and in a second-floor window, 3 women and an infant trapped by the flames. The officers, who were among the first emergency personnel on the screen, quickly scrambled over a 5-foot fence and raced up to the fire escape. Officer Diesel forced back a metal window gate, retrieved the baby, and carefully handed it over to Officer Gerner, who carried the infant to safety. Officer Diesel stayed on the fire escape to help the trapped women out of the smoke-filled apartment. This dynamic duo continued to assist in evacuation efforts. Not to be outdone by his partner, Officer Gerner rushed back up the fire escape and went into the building to assist trapped residents, while Officer Diesel grabbed the ladder to help other occupants escape the flames. Thanks in great part to these brave-hearted officers, everyone was safely evacuated, at which point Exhausted and suffering from smoke inhalation and minor injuries, they headed to the nearest hospital, where they were showered with grateful hugs and emotional thank yous by many of the same building residents they had just rescued. Officers Diesel and Gurn, your great bravery and swift and skillful actions have made us all enormously proud. For your valor, professionalism, and humanity, we are honored to present you with this year's Merit Performance Award for Heroism.
Oh, beautiful, more spacious sky, for amber waves of grace, for purple mountain majesty, above the plain, America, America, God shed His grace on thee, and crown thy good with brotherhood, from sea to shining sea. Oh, America, America, God shed His grace on thee, and crown thy good with brotherhood, from sea to shining sea.
All I have to say is affirm, affirm, affirm. Michelle, I think that is the Law Day message, and I thank you for delivering it so magnificently. We all have a great deal to be thankful for, Michelle. We're thankful to you for coming up here from the Appellate Division in New York City to be with us. We're thankful to all of those great court employees, aren't we, who received the awards, those in the audience. We're so grateful to the judges of the Court of Appeals. They're right there in the front row. To the court staff who are in the audience, so grateful to all of you. To the judges, the marvelous judges of the Unified Court System who are here today, members of the bar, to you, Lieutenant Governor Donahue, Attorney General Spitzer, State Bar President Standard. We're grateful for the sunshine.
Thank you, Lord.
Thank you, Lord. And we're grateful for America. Thank you all so much. That concludes our ceremony.